Hey folks, this is Andy Sito. Welcome back to another episode of Middle Class Rockstar. My guest this week is ABarraza, a good friend of mine from college, from music school at CU Denver, and he works for Axley Attorneys. He's an attorney there. They're based out of Wisconsin. And we chatted about a few things today, but this episode breakdown here is all about generative AI and copyrightability. It's really interesting stuff for artists and I think everybody. I think it's just interesting in general because AI is just taken over in the last, just year or two. It's really become prevalent in everyday life. Everyone's using it for something, one reason or another. So Adam kind of breaks down what generative AI is. We do an example where we create a song using AI and we play it for you. And he talks about copyrightability, as I said earlier, what needs to be done to be able to copyright something. It's fascinating stuff, and it's a pretty quick, digestible breakdown. You don't have to be a lawyer to understand what he's saying, which is great. So anyway, let's jump right into the episode, my conversation with ABarraza.
Welcome back to another exciting episode of Middle Class Rockstar. We're talking about hot topics in the music industry, legal hot topics. And the hot topic that I see most people talking about lately is artificial intelligence, or AI, and specifically the so-called generative AI, which I don't profess to be any type of expert on this technology at all. But my understanding is this is where a user enters some type of prompt, whether it be text or audio, usually text, I think, and the platform generates some type of audio output. So that's generative AI in music. Yeah.
One of these apps is called Suno. My mother-in-law loves it. She has a subscription.
Oh, okay.
Yeah, we sit when we hang out, we sit around and make songs about our dogs, and it's great. And sometimes we write the lyrics ourselves and give it a genre and say, hey, here's the lyrics. We want it to sound like this. I have this idea where at some of my solo shows, I can go out and write about the audience members really quick and have that be my walkout song.
Oh, okay. Okay, sure.
But also you can give it a prompt and Suno will write lyrics for you. So I gave it a prompt. This is a song about Adam and Andy. They met in music school at the University of Colorado at Denver. They had several classes together, but their favorite was the Claim Jumpers trad jazz ensemble, where Adam played drums and Andy played piano. Since graduating over 10 years ago, Adam and Andy have stayed in touch periodically. Now they are reuniting in person for the first time in many years to create the greatest podcast of all time.
Okay.
So
okay,
that's the prompt. That I'm giving AI. It's a silly prompt, I know, but I didn't think too hard about it. And I asked it to give me two different songs. The first was a bluegrass song featuring fiddle with a female vocalist. And it took about 10 seconds to get this.
Adam and Andy, just a wink and a sigh. In music school, they found their groove. Claim jumpers, trade jazz, making their move. With his drums, keeping time so tight. Andy on the keys, making melodies bright. They had their fling in classes, brief, girly maybe, but filled with belief. Here's a flow like notes in the air.
We'll just go through the chorus.
This dynamic pair in podcasting, made to fly. The greatest show, but who tuned by?
Okay, and then it goes into a fiddle solo. Sorry, I cut it off too early. I asked it to feature fiddle.
Yeah.
Those lyrics, and it goes on. There's a bridge and another verse, a couple more verses, but just because I didn't think the vocals were wonderful.
Yeah.
In Denver, where the Rockies kiss the sky, Adam and Andy just wink and sigh. In music school, they found their groove. Claim jumpers, trad jazz, trade jazz, making their move. Adam with his drums, keeping time so tight. Andy on the keys, making melodies bright.
Okay.
They had their fling in classes brief, girly maybe, but filled with belief.
Wow.
Years have flown like notes in the air, reuniting this dynamic pair. In podcasting, they seem to fly. The greatest show, but who'll tune by?
Okay.
So my reaction of this, Adam, and just in terms of quality, before we get into all the legal jargon of this, and I want to play a little bit of the second example too, but I'm blown away by the music.
Yeah, I think they really nailed the fiddle parts.
Yeah.
Although what I would say is, as I was listening to it, I thought the phrasing was all kind of the same for the fiddle lines.
Yep.
It all goes wait, and then descending down the scale instead of using, or I shouldn't say only, but it predominantly just went wait instead of doing other types of phrasing that maybe a good fiddle player would do.
Yeah. But better than I could do, you know.
Sure.
Well, I'm kind of blown away by the music because when I first started doing these with my mother-in-law, making these songs, I was thinking, shout out to Aaron, I was thinking, man, this could be a way that I could never have to demo a song again after a co-write that's probably not going to get cut. Not trying to be pessimistic, but we write songs all the time, and someone's like, can you demo this really quick? And they want like a track. And I thought, man, if I can somehow use Band in a Box or something to put in the chord progression and the tempo and have AI make the song really quick, and then I just sing over it, wow, I could save a lot of time. Cheating, maybe a little, but also it's a demo.
Well, so you said you would sing over it, so you can do that. It doesn't necessarily have to have lyrics. I could do an
instrumental, yeah.
Okay, interesting.
Yeah, I think I would have to use another app to, like, I was saying, like Band in a Box or something to make this work. But it was just an idea I had, and I'll probably try it and get back to everyone and see if it worked at all. The lyrics were and the vocals were not great. I felt like I could tell the vocals were AI. I bet these things are both getting rapidly better every single day. But I bet if we sat here and really constructed a prompt instead of me just putting in that prompt really quick, I bet we could get some better lyrics out of it, but that's what we got.
Yeah. And I think that's kind of where the question is, how are you using it? I think for a lot of people.
Yeah.
And I guess we'll see that some artists are using this as just more of a tool than others. So
it's a great tool.
Yeah, it can be. And I think it's interesting that not all, but a lot of the artists that I've heard talk about this are kind of approaching it the way you're approaching it.
Yeah.
So, I guess just to back up, we heard this amazing technology that generated this song.
Right.
This is one of those classic examples, burying the lead here a little bit, but this is one of those classic examples of where the law is just way behind technology. And it always has been, it always will be. That's just the way it goes. Law moves very slow. Technology moves very fast. And copyright is maybe one of the areas where it's almost notoriously slow and notoriously behind the times.
Right.
So where we're at with these technologies here is we have a whole lot of questions and not a whole lot of answers.
Yeah.
But we have some guidance that I think we can make an educated guess as to kind of where we stand and where the next steps are for this AI technology. So here's a pop quiz for you, Sido, going back to UCD here. Speaking of UCD, do you remember what the Copyright Act protects? Do you remember this? You might not, but
no.
So I think, and just to back up one step, I think one of the first questions that has to be answered when we're talking about generative AI is, what is that? What did we just hear? Was that a copyrightable song or not? And if it is copyrightable, who owns the copyright?
Yeah.
That's really important.
I'm curious. Can I put this out on Spotify and get royalties for it and all that, get pennies for it?
Yeah, it depends on who you ask, right? But what I would say is going back to the copyrightability, that's the question that we're looking at here. The Copyright Act protects original works of authorship fixed in a tangible medium of expression.
Right.
Remember that?
Yeah.
So for the audio listener, I'm using my fingers here. The first requirement is it has to be original. The second is it has to be a work of authorship. And the third requirement is it has to be fixed in a tangible medium of expression.
Okay.
So going through those kind of one by one, I'll skip to the third, the fixation requirement. All we're really getting at here is it has to be sufficiently fixed so that you can perceive it for more than a transitory period of time. So you just clicked on it on your iPad. Presumably it's stored somewhere on your iPad or on Suno's server, right? That's how you're accessing the website.
Right.
So I will just say that the fixation requirement, when it comes to this output that we just heard, this bluegrass song, we're good on that for copyright purposes.
Because it's here?
Because it's here, because we perceived it. We can go back to it and listen to it again.
I see. And would this be the same as if I just recorded a voice memo of a new song?
Exactly. That's
okay.
Yeah. Anytime
Gotcha.
you're recording anything on a hard drive or anything like that, that's sufficiently fixed for copyright purposes.
Okay.
Going to the first requirement, the originality piece, I've seen a question raised. I think it was on a blog about the question was something to the effect that, hey, if all these audio outputs are just kind of a collage of previously recorded music, previously copywritten sound recordings, right?
Yeah.
Is it truly original?
Uh-huh.
And there, I think, is a misunderstanding of the way the technology works. So I just put that caveat. But even if it was just a collage of different sound recordings, well, that can also be original for copyright purposes, right?
Sure.
Just because it's a collection of audio samples from songs, you could have an original work, a derivative work of those previous sound recordings. So you might have other problems, right? If you didn't license those samples, you might have an infringement problem.
Right.
But for originality purposes for copyright, we're good on that.
Okay.
So we're good on the first requirement and the third requirement.
What's the second requirement again?
The works of authorship.
Okay.
Yeah. So the question now is what we just heard a work of authorship?
Meaning,
we'll get into that, I guess. So when we're talking about copyrightability, I think a great place to start is, in terms of guidance, is the United States Copyright Office. And these are the good folks in Washington, D.C. who are tasked with interpreting the Copyright Act, and they administer the registration system, right? These are the people you fill out an application for your songs and they approve or deny it.
yeah.
And that's really important because, as you'll remember from UCD, one of the benefits to getting a copyright registered is, in order to file suit for infringement, it's got to be registered. So remember this, you just said, what if I record a voice memo on my phone? Remember that copyright vests with the author immediately once it's fixed in a tangible medium of expression.
Sure.
So you don't have to register it in order for you to have the copyright. But in order to sue for infringement and a whole host of other benefits, you do have to register it.
So just to repeat exactly what you said, but with a musician example, I record a song and if I do a co-write, we have our agreement, splitting it 50-50, me and one other writer, and then we record a voice memo. We both have the voice memo. We both have equal rights on it. We can do whatever we want. We don't register it. But then we hear another song after we put our song out or whatever. We hear another song that sounds a lot like it, and we're like, man, they copied our song. If we hadn't registered it with the Copyright Office prior to that, we would not be able to take any legal action on it.
Yeah, it has to be registered for you to file suit. So what would happen is you would file the lawsuit, and then they would file a motion to dismiss immediately and say, you don't have the ability to give them what they want because they haven't even registered this for copyright. And that's one of the requirements.
Okay.
So,
and it would had to have been done already. I can't go back and say, I'm going to register it for a copyright and then sue.
No, it has to be registered before you file suit.
But I mean, if I heard a song that sounded a lot like mine and I wanted to file a suit, I wouldn't. I'm just saying, and I wanted to. Would I say, well, I haven't gotten a copyright yet. I'm going to go get it copywritten and then sue? Or would it have already had to have been copywritten before I heard this person's copycat track of my song?
Oh, I see what you're saying. So there you would have a problem of damages. So the damages, statutory damages only take effect if something is already registered. So yeah, you could theoretically go register it and then file suit, but you wouldn't be able to collect statutory damages, which statutory damages, it's provided for in the Copyright Act itself, and says, hey, it's X amount of dollars per infringement. It's a huge range, by the way. But that's important because without that, you would have to prove actual damages. And what are your actual damages?
Yeah.
Who knows? Those can be very difficult to prove.
Sure.
So that's what I would say is, I think a lot of people, their practice is to release music kind of contemporaneously with filing the application so that they minimize the lag time there, or register it and then release it.
I see.
I would think major label artists probably register it and then release it.
Right.
But so we're talking about copyrightability here, and we've gone through kind of the requirements, and I'm talking about why I think the Copyright Office is a good place to start. These are the Copyright Office advises Congress and the judicial branch of government on copyrightability. And they also publish guidance. They've published some guidance on AI recently, dealing with the, like, what do they call it? Digital replicas. So, you want to enter some celebrity singing whatever, Tupac singing All the Single Ladies or whatever. That's a digital replica, obviously, because Tupac unfortunately passed away before that song was written, or at least before I think it was written. Who knows? But so the Copyright Office is a really great place to start for copyrightability. And on the question of authorship and who is an author, the copyright has taken the position that, historically taken the position that authors are human, period.
Okay.
So.
And I'm sorry I got us off on that tangent.
No, that's fine.
We had decided that this song had gotten 2 of the 3 qualifications that we needed, but the authorship is the one that is the gray area.
Yes.
Because the Copyright Office decided an author is a human.
Yes, that's the start of this gray area. It's not the end. This is where all the interesting questions for generative AI, for copyrightability, all the interesting questions are on this authorship piece here. So like I mentioned, the Copyright Office has taken the position that authors are human. And here we have a case study. I'm looking at my notes so I make sure I get this name right. But the case is called, I think you would pronounce it Thaler, Thaler v. Perlmutter. And just to back up a little bit, Thaler is the guy who's trying to claim the copyright, and Perlmutter is Shira Perlmutter, who is the Register of Copyrights, and she's also the director of the Copyright Office. So she's named as a defendant.
She gets sued all the time.
Yeah, she's named as a defendant just in her official capacity as the Register of Copyrights. So what happened in this case is, this is a visual piece of art called A Recent Entrance to Paradise. And Mr. Thaler, my understanding based on what I've read, is Mr. Thaler actually designed the AI platform itself. That's not entirely clear. But what happened is Mr. Thaler tried to register this copyright for A Recent Entrance to Paradise. And he said, look, my machine created this, but it's my machine. So
he created the machine.
He created the machine, presumably. But what he was arguing is this is a work for hire. So he said, I own the machine, and the machine created this on its own.
Yeah.
He said it autonomously created this piece of art, which for our sake, we're just going to assume that that's true. I don't know how that's even possible, but let's just assume that's true.
Okay.
So this is what he put in his application and said, I should get the copyright because I own the machine. And the Copyright Office disagreed. They said, no, you do not get the copyright because you clearly did not create this. You did not create this work. The machine is the author. And for copyright purposes, authors have to be human. Therefore, no copyright. So Thaler went through the administrative appeals process in the Copyright Office itself.
Yeah.
Which there are, I think, a few layers of administrative appeal. And then if they're still denying your application, you can theoretically appeal that decision to the federal courts. So in the federal court system, we have district courts at the bottom, and then we have courts of appeals, and then we have the United States Supreme Court, if they take your case, right? Because they don't have to.
Yeah.
Not for this. So where we're at with Thaler v. Perlmutter is we have the Copyright Office's opinion and the district court's opinion. So the Copyright Office denied his application. They said, you're not the author. The machine is no go.
Yeah.
The district court agreed. The district court said, yeah, authors have to be human. And this is coming from previous Supreme Court cases. You may have heard of there was a case where a monkey took a selfie on an actual camera. This was years ago. And it was like a researcher that had left his camera with a bunch of monkeys to, see what they would do. And it's like just this perfect selfie that this monkey took.
Oh my gosh.
So he tried to register that, and the Copyright Office said, no, authors are human. Monkey's not human. You don't get the copyright. So drawing on cases like that and the text of the Copyright Act itself, which speaks of authors in terms of human, the district court said, you don't get the copyright either. And then what I would note, the final note on Thaler v. Perlmutter is this is on appeal right now. So he's appealed it to the DC Circuit because he filed it in the district court for DC. So I think it's unlikely that gets overturned. The Supreme Court, like I said, has spoken about authors in terms of humans.
Yeah.
The whole time that we've had the Copyright Act. So that's where I think that's going to stand. So the question is, or I guess that answers the question, if the machine creates the audio on its own, is that copyrightable? The answer to that is no.
Uh-huh.
Okay. Well, now what if we use a text prompt? Just like we just did.
Just like we just did, yeah.
Does that make us the authors? Does that make your mother-in-law the author of this work?
Yeah.
And here we have a couple case studies, not actual court cases, but we have a case out of Colorado. There was a Colorado artist named Jason Allen.
Right.
Have you heard about this?
Yeah.
Okay. So Jason Allen, for those who may not know, he was involved in the creation, I would say, of a piece of art called Space Opera Theater. And it's actually the French phrase for space opera theater. I'm not even going to pretend to pronounce that. But he entered that in the Colorado State Fair, and he actually won the digital art competition.
Wow.
And then he went to register it, and he said, here's what happened. I entered a prompt in Midjourney, which is the image generating platform, and this is what I got out of it. Therefore, I should get the copyright because I did the text prompt. And the Copyright Office said no. They denied his application. And the way that Shira Perlmutter has described the way that the Copyright Office is looking at these technologies is they're likening this to written or any type of instructions that you give like a commissioned artist.
Yeah.
So, for example, let's say you wanted to make an oil painting of your lovely little family here in front of your van.
Yeah.
And you go, yeah, I want us to be standing in front of my van. I want to be holding my dog. I want to be wearing a tuxedo, whatever. But ultimately, it's the artist who interprets those instructions.
Right.
That's where the creativity is.
Well, sure. The same as if you asked me to write a song for your family for your wife's birthday,
Yes.
and then you tried to copyright it because you gave me the prompt. I'd be like, but I did it.
Exactly.
And now something that you brought up was, is it called the sweat of the brow doctrine? Or something like that, which is not a thing here in the United States. Is that correct? But that would basically say, well, I put all the work into the prompt and I finessed the prompt. The same way if the guy who wrote the phone book wanted to register that for a copyright, he put all the work into it maybe, but those aren't his phone numbers. They're other people's.
Yeah, and it's just information. So there's a little bit of a distinction to be made about arranging information.
Yeah.
So like a standard calendar is not copyrightable, but if you add creative elements to the calendar, then those creative elements are copyrightable.
So you can get a partial copyright on your calendar.
Yeah. So what happened, like you mentioned in this case with the guy from Colorado, is the Copyright Office said, no, you don't get the copyright. You entered the text prompt. He said, hold on, you're misunderstanding this is to my earlier thought. You're completely misunderstanding what this is to me.
Yeah.
This is just a tool in a long line of tools that the Copyright Office has at least initially misunderstood.
Right.
And what he actually likened it to is you wouldn't say a painter doesn't get the copyright because they didn't mix their own paint.
Right.
They didn't build their own canvas. Right.
Yeah.
So, obviously those, I think maybe mixing paint would be a more gray example of like the creative aspects of the work. But regardless, because we don't have the sweat of the brow doctrine, the fact that it took him 600 and whatever tries to get Space Opera Theater.
It's not the Copyright Office's problem.
It's not the Copyright Office's problem. So entering a text prompt is not enough.
Okay. What if I enter a text prompt to get the lyrics, but I wrote the music and I use AI's lyrics that I text prompted and put it over my music? What would the Copyright Office do then?
Yeah, then I think the copyright would give you a partial registration. So we have a couple more case studies. I want to make sure I get the name right for this person here.
Yeah.
There's a graphic novel called Zaraya of the Dawn. The human involved in that creation is named Chris Kashtanova. And what she did is she wrote the text for her graphic novel, and then she used part of that text in Midjourney to generate images to go along with her text. And then she arranged the images in the text to create her graphic novel.
Right.
So she submitted that for copyright registration, and the Copyright Office said, okay, you get a partial registration in the text and the arrangement of the text and the images themselves, but you don't get a copyright in the images. Why? Because they were created by AI using a text prompt, and entering a text prompt ain't enough.
Yeah.
So yeah, in the music context, we do have a case study. Well, it's not even a case, I would say, because we don't have any Copyright Office guidance on this, but there is a song called River of Love that was recorded by a singer-songwriter based here in Nashville named Anna Voss, I think is how you say your last name, V-A-U-S, and her brother, who's not named in the article. So, shout out to him. But what Anna and her brother did is kind of the reverse of that. What they did is they entered into a chat bot.
Yeah.
They said, we want a country song with the title River of Love. And the chat bot generated the lyrics. And then they took those lyrics and added the harmony, the rhythm, and the melody, and then recorded the song.
So they made all the music.
They made the music, which I think is probably, that might be more of a challenge, to do it that way. But at any rate, I think if they were to apply for copyright registration for that, I think what the Copyright Office would say is you clearly don't get the copyright in the lyrics because those were generated by AI using a text prompt.
Yeah.
But you can get a copyright in the copyrightable elements of the music. So there, I think we'd be talking about the melody probably. Just the melody, because you can't usually copyright chord progressions and rhythm. I'm not sure how you would do that, but what they would kind of get is the copyright in the melody. I think the melody and whatever other aspects of the music itself, the Copyright Office would give them a registration for.
Yeah.
With the caveat that, remember from UCD, when you record a song, there are two copyrights.
Yeah.
There's the musical composition,
right,
and the sound recording. And I think that Anna and her brother would get the copyright in the sound recording because they recorded it.
They made the song.
So they recorded the song.
Yeah. No, sorry. When I say they made, like they put the clay together and record. Yeah,
And
recorded.
it sounds like we're mincing words here, but I think we have to be careful.
Well, you know the lawyers speak. Yeah, you know the correct verbiage.
You have to be, with this one word can make a big difference in the way we're talking about this. But so now the question is, okay, what if Anna and her brother had changed the lyrics? Because as you noted, and as Anna noted in the article, she's quoted as saying these lyrics weren't very good. They gave her some unique perspectives that maybe she wouldn't have come up with on her own, but the lyrics weren't great. So she would have, rather changed them to begin with. And I think we would agree that maybe we could tweak those a little bit. So,
but how much?
And what would happen with that? So I think if you change them, if you take the lyrics that come out of the chatbot and you change them, you could get a copyright in those changes as a derivative work.
You couldn't just have the bot as like a co-writer or something?
No. So the way that the Copyright Office wants you to do that is they want you to explain kind of how AI helped you or AI's role in the creation, but they don't necessarily want you to name the software, because that's what people were doing. Some people were doing. They were naming the AI as the author or a co-author or something like that. And the Copyright Office said, you don't need to do that, but we do need to know who did what. So if Anna and her brother would have changed the lyrics to make them the way they wanted, then I think the Copyright Office would still give them a partial registration, and they would say, this is a derivative work. Your lyrics are a derivative work. And then you still get the copyright in the musical, the whatever copyrightable aspects of the music, namely the melody probably, and then the sound recording itself. And then the final question, I think, just to bring us back home, is what if we just use this technology kind of for inspiration?
Yeah.
Right?
Sure.
And there we're just using it as a very vague starting point and then creating our own lyrics based on that. And there I think is going to be, these are all going to be case-by-case determinations, that whether it's a derivative work or, whether you haven't made enough modifications to even make it a derivative work.
Yeah.
Your changes in other words are de minimis.
Yeah.
And where we go like, hey, I just listened to this AI song and then I wrote my own kind of independently. Those are going to be case-by-case determinations. But I think it is an interesting question to think that maybe there is a point at which you've changed it enough that that's not a derivative work. It's your work.
Right.
I think that's an interesting thought. And I think that's where we're going to get some guidance hopefully soon.
Well, and I know about, there's a lot of writers here in town that use AI for various things.
Of course.
I mean, I haven't used it in a co-write yet, but I'm sure it's coming. I also wonder this too, not that anyone should lie, but what's to stop someone from just registering the song and saying, yeah, I wrote the lyrics?
Yeah, right. The Copyright Office is kind of operating on the honor system for now. But what I would say is, if the software platform generated the lyrics, the software platform, and I'm not trying to say that this is what's going to happen, but in my mind, it's theoretically possible that the AI could recognize its own creation somewhere. And then you would have problems. You would have to go back and fix your application.
You'd be getting sued by a non-human. You'd be getting sued by a robot.
Yeah. Terminator would be, So that could be a problem down the road.
If your song blew up, right, and AI was a big part of it, AI might say, hey, that's my song.
Well, remember, if it's created by AI, it's not copyrightable anyway.
Yeah.
So, that's a sticky situation. I would also note, just as a final thought, that there might be software platforms that are later developed to where entering a text prompt in those platforms could make you the author.
I see.
That's theoretically possible, right? We don't know. We're at the very start of this technology.
Yeah.
And all we have is guidance on kind of these Suno type platforms.
Yeah.
In the way that they exist right now.
But they're still operating case by case in the Copyright Office, correct?
Yes, and that's the way they always have operated. And they review your application. They review 500,000 applications every year. That's the way it's going to be. So
Wow.
That's where I think we're at with this generative AI. If it's created by platform without any human input, certainly that's not copyrightable. If you enter the text prompt, it's not enough. If you take the output using your text prompt and you make changes to it, you could get a copyright in those changes as a derivative work. You could also get a partial registration for the elements of the work that you created. And then the ultimate question, I think, is how you use AI, how the artist uses AI, whether they use it just for inspiration, like you listening to a Van Halen record and then writing some song that doesn't necessarily sound like any of Van Halen's songs. That's important, right? We're not ripping off one of their songs, but it just kind of draws on those genre kind of 80s metal kind of elements and makes your own. Is there room for this to be used, for AI to be used in that kind of way?
Yeah.
And then where we go with the platforms, maybe there is a platform that exists that entering a text prompt could make you the author of that work. Sweat of the brow doctrine aside, there could be theoretically a platform where the Copyright Office would say, hey, you're doing enough, independent human creative work that you get the copyright.
So, Adam, just for review, you were at the very beginning of this conversation. You'd mentioned 3 things, and then you went into the gray area of the authorship. 3 things that you need to copyright something. Could you just recap those 3 things really quick?
Yeah. What the Copyright Act protects is original works of authorship fixed in a tangible medium of expression. So it has to be original, it has to be a work of authorship, and it has to be fixed in a tangible medium of expression. Those are kind of the 3 overarching elements of copyrightability.
That was my conversation with ABarraza of Axley Attorneys based in Wisconsin. Like I said before, we went to college together at CU Denver, and he went on to get a real job as a lawyer. He flew out here to Nashville just to hang out and shoot some content with me to talk about generative AI and some other issues in the music business. So if you liked it, consider writing a review, subscribing. I don't know if you're watching on YouTube or listening on Apple Music, but it just takes a second and it's a great help. Thanks so much for tuning in, and we'll see you next time.